An Ohio college student who didn't want her mom to know she failed out of school brutally killed her when she found her on the phone with the university. Brenda Powell was hit with a cast iron skillet and stabbed dozens of times. But now, in a stunning move, an appeals court has overturned her daughter Sydney's conviction, giving her the opportunity for a new trial. Welcome to Sidebar, presented by Law&Crime. I'm Elizabeth Millner, in for Jesse Weber. This is a Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And research is potentially linking ultra-processed foods to these outcomes. Morgan & Morgan is stepping in to fight to hold food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for families who deserve justice. If your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, visit www.forthepeople.com/food to learn more. Sydney Powell was just 19 years old when she attacked her mother, Brenda, inside her Akron, Ohio home in 2020. She has never denied killing her mom, who was a 50-year-old nurse to cancer patients at Akron's Children's Hospital. But her defense attorneys have always maintained that Sydney was in the middle of a psychotic episode when it all happened. Before we get into what an appeals court had to say about Sydney's conviction, let's rewind back to March of 2020. Police responded to a request for a welfare check and found Sydney in the driveway. Officers reported that her eyes were rolled back and she was clawing at the pavement. Meanwhile, Brenda was inside with severe injuries. She was rushed to a hospital but passed away. A month later, Sydney was indicted for her mother's murder as well as felonious assault and tampering with evidence. She eventually entered a not guilty plea by reason of insanity, and her father supported her, begging prosecutors not to file charges. During a pretrial hearing in 2023, Steve Powell said, quote, "I don't know why we're doing this. This isn't what anyone wants here. I don't know how she can handle it. I don't know how I can handle it. I'm trying to keep my family together." Before her trial, Sydney had been released on bail and was living with her grandparents. Her family told the court that they had hoped that arrangement could continue and that Sydney could keep getting treatment. 3 pretrial evaluations determined that Sydney was not sane at the time she killed her mom, but an expert for the state disagreed. Prosecutors chose to go ahead with Sydney's trial. In a statement emailed to the Akron Beacon-Journal, prosecutor Sherry Bevan Walsh said, quote, "We have the utmost sympathy for Brenda Powell's surviving family members. It's unimaginable and tragic to lose a loved one to violence under any circumstances, much less when the violence is caused by another family member. In the interest of justice and the community, we believe the case is best resolved by presenting a fair and impartial jury with all the facts and letting them decide the outcome." During the trial, we learned more about Sydney. She graduated a year earlier from high school with a 3.8 GPA. She earned a partial academic scholarship to the University of Mount Union in Alliance, Ohio. But when she started classes, her roommate says her mental health started to deteriorate rapidly. She was sleeping 16 hours a day and failed 3 out of her 4 classes. She was put on academic probation and eventually expelled from school. But she didn't tell her friends or family that she'd gotten kicked out. According to court documents, on March 3rd of 2020, Sydney's dad got a call at work from Mount Union, letting him know that she was no longer enrolled. He saw in a tracking app that his daughter was at their home. He went to their house and she told him she was frustrated that her friends seemed to have their lives all figured out while she had not. Her dad told her she should talk to her mom about it and asked Brenda to come home while he went back to work. Brenda Powell told coworkers she needed to go home to deal with a problem involving her daughter, and that was the last time they saw her. According to testimony heard at trial, once Brenda got home, she called Mount Union to try to figure out what was going on with Sydney. 2 deans from the university were on the other end of the phone when they heard thuds and screams. They say Sydney then got on the phone pretending to be Brenda before hanging up. The school administrators called in that welfare check, leading officers to the Powell home and the shocking crime scene. According to prosecutors, Sydney hit Brenda with a cast iron frying pan and stabbed her repeatedly in the neck with a steak knife. Psychologists who testified on Sydney's behalf said she was out of touch with reality when she killed her mom, who said she was more like Sydney's best friend. The expert testified that Sydney had flashes of that day, things like sitting next to her mom on the couch and then feeling the need to get away. She also told psychologist James Reardon that she remembered voices in her head saying things like loser and worthless. The next thing she knew, she was waking up at the hospital with minor injuries, but her mom was dead. Dr. Reardon, who examined Sydney for 8 to 10 hours over 2 days, testified he believed this was the first episode of schizophrenia. In his report, Reardon wrote, quote, "I have rarely, if ever, seen a situation where an individual was in an utterly compromised psychological state as Sydney Powell was at the time of these offenses." Another doctor testified that Sydney was completely, totally out of her mind. In total, 3 psychologists agreed that Sydney was not guilty by reason of insanity. But the sole medical expert for the prosecution testified that Sydney was not experiencing full-blown psychosis before killing her mom. In the end, the jury found Sydney guilty on 2 counts of murder, 1 count of second-degree felonious assault, and 1 count of third-degree tampering with evidence. A Summit County, Ohio judge ordered her to serve 15 years to life in prison, and she's not eligible for parole until 2038. But a new ruling from the 9th Judicial Court of Appeals could mean a change is on the horizon. The court's decision the day after Christmas reads, quote, "Sydney Powell appeals her convictions in the Summit County Court of Common Pleas. This court reverses." So here's their reasoning. According to the appeals court filing, before trial, Ms. Powell moved the trial court to permit her to call witnesses to rebut the state's anticipated expert testimony related to the not guilty by reason of insanity defense. The trial court denied the motion during trial, but before the state expert testified. After the state expert testified, Ms. Powell renewed the motion, arguing that her experts could have rebutted specific points related to the methodology used and conclusions reached by the state's experts. The trial court denied the motion again, concluding that Ms. Powell had lots and lots and lots of expert testimony in this matter. The court wrote that one expert witness the state called, Sylvia Obradovich, went beyond just giving her expert opinion. She also described her own methodology and offered pointed critique of Ms. Powell's experts, characterizing the basis of their expert opinion as both fundamentally flawed and irrelevant to the question at hand. Considering that Dr. Obradovich did not include the critique in her expert report and the state's cross-examination of each expert was minimal, it may well have been impossible for Ms. Powell to do so in any event. Ms. Powell's proffered rebuttal, therefore, would have been evidence given to explain, refute, or disprove new facts introduced into evidence by Dr. Obradovich. This court therefore agrees that once the state's expert had testified, the trial court erred by denying her the opportunity to present rebuttal testimony. The appellate court ordered the Summit County Court of Common Pleas to carry this judgment into execution, which likely means Sydney will be granted another trial. So far, no word on when that might happen. So for now, Sydney is incarcerated at the Ohio Reformatory for Women in Marysville, Ohio. A stunning win for Sydney Powell, seemingly. Let's bring on now trial attorney Diane Menashe. Diane, thank you so much for joining us today. Now, you're from Ohio and know this case very well. What's your reaction to the appeal court reversing Sydney Powell's conviction, and are you surprised by that decision?
You know, I wasn't surprised because in Ohio, if your defense team raises a defense of not guilty by reason of insanity, it's your burden. And so when the judge denied the defense the opportunity to rebut the state's expert as to the mental health issue, the judge was literally denying the defendant, the opportunity to actually present their defense. And so that's what makes this really, I think, an unusual case and decision. And I wasn't surprised. I was surprised, though I remember when this case came out, that the judge didn't allow them to put forth the rebuttal evidence, given that it's the defense's burden.
And talk to me about the appellate court making a decision like this and kind of the weight that this holds. While her conviction is overturned right now, Sydney still remains behind bars.
Yeah, I think if we think about it in the other way, like if, we all know that the state has the burden of proof beyond a reasonable doubt. And if there's a scenario, if any of us could imagine, where they wanted to produce, the key expert as to mental health, and the judge told the state of Ohio they couldn't present that evidence, it would be the same exact thing. It's just the coin is on the different side here. So I think the appellate court is clearly saying that when you have the burden of proof, you should be able to present the case that you believe is necessary to meet that burden.
And the facts of the case are pretty shocking on paper, right? You have a daughter who murders her mother, something she didn't deny. She hit her over the head, or hit her over with the cast iron, stabbed her multiple times, all because she didn't want her mom to find out she had failed out of school. What are your thoughts on the crime overall? And do you believe the defense's theory that she was going through psychosis?
Well, we do have a situation where the defendant had a prior mental health diagnosis of paranoid schizophrenia. So this wasn't, a defense team that was raising mental health as this is the first time the client had been diagnosed. With that said, I think sort of the oddity, if you will, of the reason why, her mother was killed does lend itself more to a mental health defense than not. But I think that's what we all know about mental health, right? Like, it's very difficult to understand. And if it was understandable, we all, particularly in the justice system, would be in a very different place. But they did have 3 experts that testified as to her mental health, certainly said that she was under a psychotic break at the time. And as we know, just from mental health, a psychotic break isn't 60 seconds or a minute, right? That, you could be in a state of psychosis for hours, days, etc.
And given what the defense experts testified during trial, are you surprised the jurors found her guilty?
I am a bit, but it also, I think, lends to the appellate court reversing the case, right? They had 3 experts, the state had 1. And really the game changer for the state expert was that the state's expert, went beyond their expert report and not only opined that she wasn't in a psychotic state, they went further to say that the defense experts were using the wrong methodology in coming up with their conclusions. So I think, to your point, a rebuttal expert really could have sealed the deal for the defense. And I read the appellate court decision last night. It's that but for language, right? Like, had the state or had the defense been able to rebut the state's expert, the verdict could well have been not guilty by reason of insanity.
And do you think it's possible, given her father's previous support of Sydney, that prosecutors could strike a deal with her? Is it possible at this stage?
Certainly one would think so. Under Marcy's law, obviously, her father will have a real voice in terms of whether and how the case moves forward. I would think what's tricky with that is that this is obviously a very new case, right? She was convicted in 2023. The murder was in 20. So she hasn't, there isn't that great distance that we often see in cases like this that are sometimes reversed, where the defendant or the client has served 5, 10, even longer years. But I do think it will be very interesting to see how the state handles the case moving forward. Do they try to get a sort of a lesser plea, perhaps, albeit, a low-level felony or even a misdemeanor involuntary manslaughter type thing? Or do they move forward with the murders as originally charged?
I definitely want to get your take on, what do you think that her retrial could look like? And do you think that it's possible that she could switch counsel for her next trial?
I think it'd be such an interesting case to try. There's always sort of the natural inclination, if you've just had a trial, that wasn't successful, if you will, right? Like, that trial resulted in a conviction where I think an individual, any of us, would be really more likely than not to say, let's do it different with a new team. I also think the appellate court decision will give her defense team, whomever it is, a real roadmap in terms of what needs to be put forth the second time around. But certainly if she switches counsel, anyone that should get that call, I think this would be an incredibly interesting case to try. There's no question about that.
And Sydney Powell, she didn't take the stand in her first trial, but do you think it's possible she could take the stand in her retrial? And is it something that you would advise her to do?
The number of times that we certainly suggest, or we opine that a client should take the stand is so rare in this line of work. Of course, in the end, it's the client's decision. But I can't imagine a situation where she didn't testify in her first trial. As I understand it, she had never made statements to law enforcement, that now all of a sudden she would take the stand. I certainly can't imagine that scenario, but of course, as we all know, it's up to the client, and the client can decide in real time. The state could close their case and the client could say, I've made a decision that I now want to testify. So only time will tell as to that decision.
Yep, and I guess we'll kind of have to wait to see how this all continues to play out. Diane Menashe, I want to thank you so much for your time today. But before we sign you off, how soon do you think we could see a retrial for Sydney Powell?
I think the first issue that's going to happen is her bond, right? Is she released on appellate bond? And then I think she's got to then really decide who her defense team is, because it's that defense team that's going to start negotiating with the state of Ohio as to how, if at all, the case will move forward. So I would suspect that in the next 90 days, we have a very good sense of, is the state moving forward with the case as indicted, or is there a new team in place? The negotiations are underway. So I would think 90 days, we should have a real good idea of what's to come for this case.
All right, Diane Menashe, again, thank you so much for your insight into this case. I really appreciate your time today, and Happy New Year.
Happy New Year to you. Take care.
All right, that does it for this episode of Sidebar. Be sure to subscribe to us anywhere you listen to your podcasts, whether it's Apple Podcasts, Spotify, or YouTube. I'm Elizabeth Millner in for Jesse Weber, and on behalf of all of us here at Law&Crime, have a great, happy, and safe New Year's.